Appeals Division 1 is now in session.
Thank you. You may be seated. We're here today in our case number CV140733, Kilpatrick versus Johnson. Judge Sam Thumma is not feeling well today, and in the interest of not contaminating the courtroom, is not here. He has participated in our pre-argument discussions, and he will be listening to the argument or watching it on YouTube after it's over, and will also participate in the decision that we ultimately issue. These proceedings are being videotaped, so we'd ask when you approach the podium to please identify yourself and your client. Each side has 20 minutes. Appellant, you'll need to reserve whatever time you want for rebuttal. We have discussed this matter and conferenced it. We're familiar with the facts. We've read the briefing, and we're looking forward to your argument. And with that, counsel, you may proceed.
Good morning, judges. My name is David Lunn, and I'm here with Randy Nussbaum. We represent the appellants, Dr. Kilpatrick and the SSP Trust. This is a case about a manager's duties to the members of an LLC. Here, the SSP Trust is a member of the Scottsdale Laser Vision Center, and the administrative manager is Dr. Johnson. And Dr. Johnson, the members entrusted Dr. Johnson with control as the administrative manager.
Well, in your counsel, can you clarify? Are you arguing that Dr. Johnson was the manager of the LLC, as that term would be normally understood? Because from my reading of the briefs and the record, it seemed like he just did administrative matters for the LLC, and that therefore members together manage the LLC.
It's that way in part, that he was deemed the administrative manager, but in fact, and the obligations in the operating agreement also gave him other responsibilities that were distinct from the other managers of the company. For example, he was pursuant to the resolution of the company, the only manager, the administrative manager, who was charged with opening bank accounts and signing authority on behalf of the company.
Isn't that more of a clerical responsibility? If everyone has to agree, if he can't write a check that the other managers don't agree on, if he's just the person who has the authority to sign the checks, isn't that more of a clerical duty?
Well, potentially, but it wasn't the case here. The case here is that he had carte blanche authority to write checks. He had
So he combined the LLC without consulting the other managers?
On certain matters, there are certain matters under the agreement that were excluded that he needed a two-thirds vote to be able to do so. But there were instances where he could sign it. He was the signature on behalf of the company. He was the one in charge of managing all the funds of the company.
But, well, I understand that he was the person authorized to sign for the company, but I guess what I'm trying to figure out is, was he a manager such that he could act on behalf of the LLC without consulting and without regard to what the other members wanted? And that seems contrary to my understanding of the record.
Well, as the administrative manager, he did act without the authority of the members on numerous occasions. He would make capital calls without having a meeting without getting consent of the members. There's argument that these capital calls, that they're supposed to be made through meetings, and those could be waived by people not by just agreeing to pay them. There's also issues where he's making capital calls, and instead of really calling them capital calls, he's saying that these are facility fees. He's requesting money from the members for the operation of the business without stating what those calls really are for. You can't disguise those as facility fees when they're really capital calls being brought in to pay off debt of the company, which was understanding of the members that you weren't going to be paying creditors of the company until the assets exceeded the liabilities.
And were the members obligated to do as he requested when he made a capital call?
Under the agreement, there's capital calls. They were obligated to make the contributions, or alternatively have their shares diluted.
Because he told them to? And is that your argument?
Oh, no, Judge. It's under the operating agreement. The operating agreement under, excuse me. Let me just.
No, I understand they're doing it pursuant to the operating agreement, but I guess my question is he doing that because he is the boss of the LLC?
Yes, because Dr. Johnson was charged with running the company. He was charged with making sure that the duties he assumed on behalf of the LLC, on behalf of its members, was that he was going to be the person responsible for making sure that click fees and facility fees are collected and used with the Vistix laser. He was also going to make sure that those fees, how those fees were used, that the company collected. The facility fee goes towards payment of the facility as far as rent and staff and things of that nature, while the click fee went back to the company. And then the company then, under the direction of Dr. Johnson, was to use those fees to further the interests of the company, i.e., he was supposed to use those fees to pay on the Vistix laser lease, which was from Scotts July Surgery Center. He was then, other obligations of the debt of the company he was going to pay back, and then once those funds are if they're properly managed, at the end of the day, it was anticipated there'd be funds that the members of the company would actually receive financial gain from the company after they got their capital contributions paid back, after they got their loans paid back, and it was anticipated that there were going to be profits of the company. And so, as managing the administrative manager, that was his responsibility. Nobody else had that responsibility. Dr. Johnson voluntarily assumed that responsibility, and he knew that in doing so, he was charged with the obligation to act in the best interest of the members of the company.
Why was paying back a loan that everyone had personally guaranteed, or that your client had personally guaranteed, why would that be outside the scope of his duties, Mr. Johnson's duties?
Well, if you look at the terms of the operating agreement, that creditors, including the loan, weren't to be paid back out of capital contributions.
But your client doesn't dispute that he signed a personal guarantee of that loan.
I have two different clients, Your Honor. I have Dr. Johnson, or Dr. Kilpatrick individually, who was sued on a promissory note, and I have the trust, who is a member of the LLC, who, if they didn't pay capital calls, that their interest would be diminished. They didn't have an obligation necessarily to pay the loan back, and the loan, and it kind of, it's the tail wagging the dog argument here, because you're saying, okay, so even if you have Dr. Kilpatrick at the end of the day guarantees the loan, well, when Dr. Kilpatrick guaranteed the loan and the SSP trust entered the operating agreement, it did so with the understanding that the Vistix laser would be acquired and used, and funds generated off that to pay off the obligation to Scotts July Surgery Center, to pay off the contributions they made to the company. And so when you look at the actions which happened with the company, and then there was the covert meeting, which we call it, is where the only meeting, there was three instances which were major decisions in this company. The first major decision was to form the company, to acquire the rights to the laser, to set it up next to Dr. Johnson's office and to figure out what type of fees we're going to do it. The next major decision of the company, all 4 members participated in the first decision. The next major decision of the company was to move the location of the Visic laser to Dr. Petlin's office, which all 4 members were present. All 4 members discussed that. And the decision was made to move it to Dr. Petlin's office for economic reasons, believing then they wouldn't have to pay the lease payments on the other building. And with Dr. Petlin and other users, it would generate more income, which would then help pay the obligations of the company back quicker and ultimately result in a profit to be shared equally among the members of the company. All 4 members participated in that. The third meeting, which is probably the most critical meeting of all the meetings of the company, was a meeting where Dr. Kilpatrick was absent. It was the only meeting. The meeting wasn't properly noticed, and at that meeting was decided that the laser, that the company would no longer require
Were
payments.
any meetings properly noticed throughout the history of this entity?
There's a waiver argument that they weren't, because a lot of the meetings would happen, most of the meetings, almost every meeting happened after the members with the Scottsdale Eye Surgery Center, their board meeting, and they'd get to go there afterwards and talk about the affairs of Scottsdale Laser Vision Center. This was the only meeting that was held in the absence of one of the members. And so the meeting requirements before weren't necessary because everybody was present.
Well, I have 2 questions. First, there's no indication that they arranged the meeting in such a way to exclude Dr. Kilpatrick, correct? He just happened to not be there for his own reasons because he was at the other meetings that you've discussed.
I would say, Judge, that's a very good question, but I would say that when you're making a meeting, when you're having a meeting, which is going to impact the entire viability of the company, and you haven't given notice that to one of the members, and you have that cell phone number of that member's in your that's the number of the cell phone, and you should at least call him and tell him we're doing this. There's absolutely no notice of the meeting. There's no, and quite frankly, as it's undisputed, it wasn't for about a year later, after the meeting occurred, that Dr. Kilpatrick even learned of the meeting. It wasn't until a year later that Dr. Kilpatrick learned that these facility fees.
Well, but as I understand the record, he knew that there was the SESC meeting and he just couldn't attend, right?
Oh, no, not at all. He knew nothing about the meeting. He knew nothing at all. He didn't know the meeting occurred for a year later. It's undisputed in the record that they didn't notify him of the meeting. They didn't tell him the meeting occurred. They didn't tell him what action was taken. There were no minutes of the meeting which showing him which actions were taken in the meeting in his absence.
So this was the meeting was not a regular meeting of SESC?
Correct. It was not a scheduled meeting.
It was just ad hoc then?
It was my understanding of the meeting that had occurred that Dr. Petlin was present with the other 3 members, representatives of the entity, and at that time Dr. Petlin said, we're going to need to change the dynamics of this agreement we have with regard to paying click fees to the LLC. And it was during those meetings, it was an informal meeting where they were together, but it was a meeting nevertheless because there was a quorum there and they made a decision. And they made a decision that was adverse to the interest of the company.
And your discussion of all of the meetings where the 4 members were present to make significant decisions for the LLC leads me to believe that if that's the case, if the 4 of them have to meet to make the significant decisions that you've talked about, then Dr. Johnson really isn't a manager in the sense that we've been talking about, that can direct the LLC. He just, as Judge Caetano refers to it, he has certain additional clerical responsibilities, but he's not managing the company, or else he would have made the decisions in the other that they otherwise meant to figure out.
No, I understand your point, Judge, and It's true that to make major decisions, this is one of the major decisions, you need a majority vote to do so, 2/3 vote. And
is there some suggestion that the other members would have changed their vote, or had Dr. Kilpatrick been there?
Well, let me ask you this, Judge. This is a 3-panel appellate panel, and if you two go off this weekend and issue a ruling without any input from Judge Thuma, and his opinion, he believes he would have went the other way, but nevertheless, you could make that determination because two could out rule the other one, and that'd be the rule of the case. But I can guarantee you that he would want to be heard. He'd want the opportunity to persuade you and discuss with you his views and potentially get one of you to go his way so the different decision is made.
But you've now had a period of time. This lawsuit doesn't it isn't against the other two members. There's no suggestion that he's presumably had an opportunity to talk to the other two after learning about the vote and after learning about the change to to how it was set up. But there's nothing that suggests that it wasn't really a 3/4 vote. So it's hard to come up with a basis for saying the decision would have been different with him there.
Well, that's for speculation. That anybody could say it was going to be different or not. And it's really to the extent that did he have a right to be notified of the meeting? The answer is
yes.
yes.
Why is it speculation after the fact? He's had an opportunity to talk to the others, and if they don't come forward and say, yeah, I only did it because I didn't understand what Dr. Kilpatrick's position was, and I never would have gone along with that. Instead, there seems to be a suggestion that it's, well, there was an economic reason for doing this. That's why we went down this road.
Well, I think that you're going to see in connection with the trial their affidavits saying we would have decided the same thing. And that's great. Hindsight is great in 2020. The fact of the matter is that this event wasn't even discovered by Dr. Kilpatrick until a year after it occurred when he kept paying off. And so at that point, everything became litigious and people solidifying their positions of what they're going to do. And so I don't think it's a fair statement to say that can we go back now and ask these doctors how they would have voted. I think that you have to look at it at the same time when you're making the decision, whether or not before the decision is made, whether or not if you have the opportunity to be heard. And at the end of the day, if he has the opportunity to be heard and the decision is still against him, we're not standing here necessarily for that particular issue. But that is one of the issues, one of the critical issues. And I would also remind the court why you wonder about the role of Dr. Johnson. Every single physician contributed money to the entity. The only person that ever got paid back was Dr. Johnson. He put in a loan for $80,000. He had a capital contribution of $2,500. He also made another loan to the company for $11,500. He got paid back $98,000.
Are there other loans that were personally guaranteed that were not repaid?
Not to my knowledge. The other loans are loans from the members to the company, operational to get it started. But the amount of money that Dr. Johnson received back, he was out of pocket, no money at the end of the day. No other doctor received a penny out of this organization because no other doctor had control over the purse strings. No other doctor had the ability to know where all the money, it didn't know where the money was going. They relied on the representations of Dr. Johnson. They relied on the fact that Dr. Johnson agreed to and accepted the charge of being responsible for the finances of the company.
Could I ask you just, and you've asserted that there's some fiduciary duties that are owed by Dr. Johnson. What duties are you suggesting are out there beyond what's specified in the operating agreement?
Well, the duties are specified in the operating agreement, and when you look at
if everything's specified in the operating agreement, why do you need some additional duties?
Well, I think that if you look at the structure of an LLC, and we look at the TM 2008 case and talking about, well, we're not going to view it as a close sale corporation or partnership unless there's duties excluded or provided for in the agreement, then those duties don't exist. And the TM 2008 case goes on to say that looking at the provisions in that agreement, even though it wasn't going to do the mechanical application of the closely held corporations and partnerships, it said when you look at the duties that are given to the managers or the members of that case, these could give rise to duties of loyalty. And that's the question, the fact here, Your Honor, is that this isn't a case that should be thrown out in a summary judgment. The question of duty, whether or not the obligations under the operating agreement that are assumed, that are undertaken by the manager, give rise to a fiduciary relationship, and then whether that was breached. That question of duty wasn't a question that should have been answered as a matter of law. It's a question that the jury should have considered the facts. They should have considered the operation of the operating agreement and how the company functioned. So I'd like to reserve the rest of the time for rebuttal.
Good morning, Your Honors. My name is Joe Schenk. I represent Appellees David R. Johnson and the Number 8 Trust. And based on the questions, I'm going to deviate from what I had originally anticipated saying today and try to address some of the questions that were raised during appellant's argument. First of all, you asked the question about whether or not the managers of this company were the ones who were authorized to make principal decisions of the company, as opposed to the administrative manager position held by Dr. Johnson or the backup administrative manager position held by Dr. Kilpatrick. And the short answer is that the operating agreement is crystal clear. If you refer to Trial Exhibit 1, paragraph, I think, 11A, it states, quote, exclusive and complete power to manage and control the business and affairs of the company and all of the rights and powers provided to a manager or a manager-managed limited liability company by law, including the power and authority to execute instruments and documents, to mortgage or dispose of any real property held in the name of the company, and to take any other actions on behalf of the company, whether or not such actions are for carrying on the business of the company in the usual way, end quote. That is what is provided for as far as who manages this SLVC, the limited liability company we're talking about. Not the administrative manager, but the managers. All four managers. If this court were ever inclined to deviate from the principles discussed in the TM 2008 decision, this would be the worst possible case for them to do so, because what you had here was you had a limited liability company that was formed by 4 doctors, each of whom was a 25% member. They later assigned those membership interests to their revocable trusts, but you had the 4 doctors, they're the original members of the company, and each of them had the authority to name a manager. So they named themselves. And so you have a manager-managed company, according to the LLC statutes, but it has 4 managers, Dr. Kilpatrick, Dr. Johnson, Dr. Tozer, and Dr. Kahn. And those 4 managers are the ones who, under the provision in the operating agreement that I read earlier, had complete and total authority to manage the affairs of the company in this case. That's what the operating agreement provides. So if you were to want to deviate from the principles of TM 2008, you would have to say, well, what principled reason would there be to say that you have 4 members that manage the company and they don't owe fiduciary duties in a member-managed company versus a manager-managed company where all 4 members are also managers? There's no delegation of responsibility to a third party, some sort of entrustment of the corporate or company financial wealth to a single individual. They're all taking equal control of their own interest in the company.
Would there be any type of breach of duty if there? Let's hypothesize that there was not that there were not personal guarantees on the Johnson loan. Would it be a breach of duty had that loan been repaid first before other obligations?
It's an interesting question. Obviously, it's not the facts we have here, but I'd have to say if it amounted to, there's an indemnity provision in the operating agreement that basically says the company indemnifies the managers unless they commit like intentional wrongful acts or maybe even gross negligence, I don't recall, but it's in the operating agreement. I suppose if what you're proposing is if that amounted to an intentional wrongful act, basically stealing money from the company, then I think that, yeah, that's something for which you would be able to hold them accountable. But that's not what we have here. We actually have a situation where 3 of the 4 managers made a decision. And it was a very rational decision. And Dr. Tozer, Dr. Kahn, and Dr. Johnson all testified at trial as to why that decision was made and why it made financial sense to them to make that decision. You have here simply a case where you have a minority member who disagrees with the other 3 members as to what was in the right interest. And frankly, if you look at the financial circumstances, the 3 managers were probably right. They certainly had the power, because there also was a provision in the operating agreement that said that even if you don't have a meeting, if you have written approval by 3 of the 4 managers, it's the same effect as if it had been decided at a meeting. So ultimately,
you would acknowledge there is a possibility that one member may be disproportionately damaged by a decision by a three-fourths majority, actually a 2/3 majority.
There are instances where you can get into a minority oppression. This is not in a minority oppression case, though. Again, what happened here was he claimed breach of fiduciary duty, and the court held correctly and consistently with the TM 2008 case that Dr. Johnson owed no more fiduciary duty to the company than did Dr. Kilpatrick himself, because they were on an equal plane. And so the operating agreement did not create any specific fiduciary duties on the part of any of the managers. In fact, it, to the broadest extent, it could, exculpated them from such duties. And so given that operating agreement, that conscious decision of the 4, this is how they're going to run the company, I submit that there's no basis here to find some sort of, translation from common law, closely held corporations or partnerships, and try to draw that into this limited liability company, particularly in the face of the published decision, the TM 2008 decision, where they say, now limited liability companies aren't like partnerships, they aren't like closely held corporations, they are a matter of contract, and it is the contract, the operating agreement, that governs what duties exist. And if they're not in that operating agreement, they don't exist for limited liability companies. And I submit that, as I started out, this would be the world's worst example to try to deviate from the principles announced in TM 2008.
But is your argument that even if there were some sort of common law fiduciary duty out there, that Dr. Johnson is not in any kind of special fiduciary relationship?
I think so. I think the other thing I'm trying...
The other doctors.
I think that in the context of what happened here, I don't believe that there was any fiduciary duty that Dr. Johnson owed the members with respect to making this business decision. And remember, ultimately, it's being treated as if Dr. Johnson made this decision. But Dr. Tozer, Dr. Kahn, and Dr. Johnson all testified that it was their decision. They collectively, all 3 of them, agreed with this decision, and that they had reasons, which were provided, it's in the record, explaining why they thought this decision was in the best interest of the company. And without getting into too much detail, it basically amounted to the fact that Dr. Petlin came about a year after all 4 members had agreed to move the physics laser into Dr. Petlin's surgery center, came to him and said, look, I'm losing money on this deal, and I'm going to have to raise the facility fees that I charge each of you to use my surgery center because I am losing money and I can't cover the losses anymore. And Dr. Kahn, and this is in the record, testified, well, if he had raised the facility fees, it would no longer have been competitive. It was a very competitive market because they're all doing this elective laser eye surgery in a time when, we're not talking about 2007, 2008 when the economy's, not good and people are not doing elective surgeries at the rate they once were. And so he said, I would have elected to take all of my surgeries to another facility closer to my office that would not have charged me a higher facility fee. And the problem was Dr. Kahn was doing over half of the total procedures being done by the 4 doctors involved with SLVC. Losing his surgical volume would have been very, very damaging to them. And so at that point, Dr. Pedlin, rather than lose Dr. Kahn's work, said that he would make an alternative proposal, and that was he would keep the facility fees at their then existing rate of $750 an eye, if in exchange SLVC would agree to stop charging him a click fee for using the Vizix laser. And Dr. Pedlin had all the negotiating power because he already owned his own laser. He didn't have to use the one that SLVC provided. The Vizix laser was a little more current, a little better laser, but it was, before he had moved they moved the Vizix laser into Dr. Pedlin's surgery center, he had been doing his own eye surgeries there with his own laser. So he didn't need it. He did not have to use the Vizix laser for his procedures either. So SLVC, the three managers who were present when he raised this, decided they had him over a barrel, and they decided that the better option, rather than losing Dr. Kahn's volume, was to agree to forgo the click charges. That's how the decision was made and why it was made.
Does the record disclose why Dr. Kilpatrick wasn't there?
I believe it does. I believe the testimony was he was on vacation or something. Again, the history of this company, they had never, not once, again in answer to a question, ever sent out a notice of any kind of a member or manager meeting. They were all partial owners in this other surgery center, Scottsdale Eye Surgery Center, which is a larger, more formal operation. And that company held monthly membership meetings. And so it was the practice, since Dr. Kilpatrick, Dr. Johnson, Dr. Tozer, and Dr. Kahn all owned interest in the SESC facility, they would stay over after that member meeting and they would conduct any business that they had to do regarding SLVC. And so they never bothered. They always just, they're just doctors. They're not lawyers or businessmen, and they just stayed around and conducted whatever business they needed to do on behalf of SLVC after the SESC meeting was concluded. Dr. Pedlin was also a owner in the Scottsdale Eye Surgery Center. So that's why he happened to be there when that one particular meeting in July of 2009 occurred, and why it was convenient for him to approach the three SLVC members who were there with this statement that he was losing money and that he was going to have to change the deal. So it was a very impromptu, just as every one of their meetings had been impromptu. And ultimately, there was nothing done here that cost Dr. Kilpatrick any more money than anyone else. In fact, Dr. Johnson testified that he had actually lost more money in this deal than Dr. Kilpatrick had. The guarantee...
Why would he have lost more?
Because he put more money in and time in that he never recouped over and above his formal loan, and he also, the guarantees were not like one-third, one-third, one-third. The guarantees were 25%, 25%, and 25%.
But he wasn't going to be entitled to a disproportionate share of the profits, I assume.
Correct.
So
he was a straight 25% participant in
so
any
whatever
profits.
his initial expenditure of time and resources wasn't something that he was expecting.
No, but the problem is, the point is, it was a misstatement to say that he was the only one who got his money back, because that's just a flat inconsistent with the record.
But it's probably, it is accurate to say that the people who used the facility more benefited more from the revised deal with Dr. Pedlin than those. It just, because the facility fee was lower, they benefited more than someone who didn't use it as often.
Well, and conversely, that's correct. And the flip side is also true. When they were getting paid the click fees, those who were not actually using the facility as much were getting the benefit of the facility fees paid by the heavy users. And as I said, the testimony is very clear, and Dr. Kahn confirmed this in his trial testimony. He was using more than 50% of the total. So Dr. Johnson, Dr. Tozer, and Dr. Kilpatrick were all at lesser amounts. I think Dr. Kilpatrick may have testified he was doing like 15% or something. And then ultimately, they had all personally guaranteed the lease, and they had all personally guaranteed the initial startup capital loan that Dr. Johnson made, the Johnson loan. And one of the things that, I don't really understand is maybe it's just because it was classified different, but they all signed this funding agreement at the same time that they signed the operating agreement. And the funding agreement specifically stated that if there was insufficient revenue coming into the company to cover its operating expenses, the company had the right to require the members, the four members, to make operating loans to the company, which could then be used to pay all operating expenses, including repayment of the Johnson loan. That was explicit in the funding agreement. And if the quibble here is that they were called facility fees rather than operating loans or capital calls, it ultimately doesn't matter because the company never turned a profit. There was no distributions made to any of the four doctors ever. It was always set up to be basically a break-even proposition so that there would be a facility that was capable of providing them the lowest possible facility fee when they wanted to do their own eye surgeries.
Why would you go into that, though, if there's no expectation of a profit? Why would you want to go in if you're only going to use it 15% of the time? And why would you want to go into a partnership with people who are going to use it a lot more than you if you're going to be on the hook and you're not going to expect some profits?
There's a couple of reasons. First of all, their real money on this is made in the professional fees. It's the professional component of when they do the eye surgery.
But isn't that tied to how many times you use it?
Again, but they make a lot of money on the professional fees. And they can charge, it was a competitive market. If you can charge $2,000 an eye and that's all you can get, then if your facility fee is $750, that means your professional fee can be $1,250. If your facility fee is $1,200, it means your professional fee is only $800. So if you have a product, which is what this is, that is highly competitive and people shop for cost as well as quality of the surgeon, then the lower your facility fee, the more money you make on the professional fee side. And so the objective here was not we're going to make a bunch of money by charging high facility fees to ourselves. It was we're going to charge the lowest possible facility fee, and maybe we can generate revenue from other doctors coming in and using our facility. That was the hope, that other unaffiliated doctors would come in and use their facility. There were a few instances of that, but it never really materialized. Another advantage of the initial proposal to move it to Dr. Pedlin's office is that Pedlin had a heavy volume, and if they were getting click fees, that was going to add outside money to the kitty. But obviously, a year and a half later, when he says, I'm not going to do that deal anymore, they were faced with a hard choice. I've got a couple minutes left. I just want to talk about some of the other issues. There's this issue about the court committing error by granting a motion in limine excluding evidence of Dr. Kilpatrick's consequential damages. You need to understand what he was talking about. The consequential damages he was talking about is that the Vizix laser was actually owned by Scottsdale Eye Surgery Center, where all these people had an interest. It was not being used because they were using their facility for cataract surgeries and other things that were more profitable. And so it was available, it was unused. They were able to get a sweetheart lease where they were leasing the Vizix laser from SESC. When this went down and the click fees were no longer being paid, there was no revenue to pay the lease payments to Scottsdale Eye Surgery Center. So Dr. Kilpatrick was wanting to argue to the jury that not only was his loss all the click fees that hadn't been collected, it was his 13% interest in Scottsdale Eye Surgery Center that was harmed because of the lease payments that were not made to Scottsdale Eye Surgery Center, and therefore he should be allowed to ask the jury for that 13% of the unpaid lease fees, equipment lease fees. A whole bunch of problems with that. First of all, it wasn't disclosed in any disclosure document. And their position at trial was, well, we mentioned it in a declaration that we filed in support of a summary judgment motion that we lost. I said, yeah, but I took Dr. Kilpatrick's deposition. I asked him twice what his damages were, and on both occasions he stated that his damage, both in the direct and in rebuttal examination, he stated that his damages were those outlined in this exhibit that he put together, which was basically his contributions to the company. There was no reference to the money that he could have or should have made as an investor in Scottsdale Eye Surgery Center. And so I think the record fully supported the trial judge in granting the motion in limine. But even if it hadn't, it was a case really of harmless error, because ultimately he would have not had any standing to bring a claim of that type when it was a claim that would have and should have been brought by Scottsdale Eye Surgery Center, the entity, because that was the entity that didn't get paid its lease fees. And you know, he didn't sort of as a derivative claim on behalf of Scottsdale Eye Surgery Center. He didn't do any of the requirements to state a derivative claim. So even if the court was willing to buy this as a properly disclosed element of damage, it was one he would never have had standing to pursue in any event. And then the denial of the motion for a new trial, all I can say on that is, you know, it took the jury like 45 minutes to come back unanimously with a defense verdict as well as a verdict in favor of us on the counterclaim. And there's substantial evidence in the record to support the jury verdict.
Thank you. If you could put 3 minutes on.
Thanks. Just like to address a couple issues that were raised. One of the issues is there's a dispute amongst the members of whether or not the LLC was ever going to generate a profit or whether they cared. But I can guarantee you there's no dispute that none of the members of the LLC expected to lose money and to lose their investments in the LLC. And we focusing on the fiduciary duty issues, and one of the talking about certain provisions in the operating agreement which are fiduciary in nature, and one of the ones that we've talked about, a few of them. Another one for the court to look at is paragraph 13, the profits and losses, where it's the administrative manager who is charged with allocating profits and losses among the country. So all these duties that are within the agreement are fiduciary in nature. And we also have to look at the course and conduct of the parties in their dealings under the operating agreement. And it was that Dr. Johnson controlled the entity. He controlled the finances of the entity. Major decisions were made, like we said, with meetings. There was a decision, the meeting that we talked about, the covert meeting, where Dr. Kilpatrick wasn't there.
But the decision was made by more than 2/3 of the overall
I agree.
members.
I agree. And I heard argument that, well, Dr. Khan testified at trial that if he was he had the most cases, and if the facility fee was going to be raised, that he was going to take his cases somewhere else. Does that mean if the facility fee was raised from $750 to $800, he would move somewhere else? Does that mean whether or not Dr. Petlin said, well, I want to keep the entire click fee instead of paying that to Scottsdale Laser Business Center, and the counter could be, well, will you pay us half of that, and $60 come at us? So there's all these conversations that could have occurred, that would have occurred, but for the absence of Dr. Kilpatrick. And so really at that point, Dr. Khan, Dr. Tozier, they deferred to Dr. Johnson on the opinion that Dr. Khan said he didn't want the fee raised because that would impact him the most. But the issues of whether or not there's going to be no fee or whether there should be a reduced fee, whether those things weren't discussed. And as an equal member of an LLC, there was an entitlement to have the opportunity to be present to discuss that amongst his peers.
Well, counsel, you sued Dr. Johnson and his trust, correct?
Yes. Well, yes. No, we sued Dr. Johnson as the manager.
Okay. But if the operating agreement provides that all of the members are the managers, why didn't you sue the other two doctors? Because that seems to be a management decision that all three of them made, and not just Dr. Johnson.
Well, part of the issue is that notice is supposed to be required of the meetings. The administrative manager is supposed to take minutes of the meeting and distribute the minutes. Those were never done. Had minutes been issued after the meeting, Dr. Kilpatrick would have known of the action that was taken that was detrimental to the company and detrimental to the members' interest, and that there's going to be no more revenue generated for the company.
So the basis of your action is failing to take minutes?
Well, it's part of it. It's if you look at the cumulative relationship and what the administrative manager agreed to do and what the duties is assumed to do under the agreement. And the administrative manager, it's a multiple of issues where you look at it and say, so you have these factual issues as to whether or not there was fiduciary obligations under the agreement, whether or not these clauses and the course and dealings created a fiduciary relationship. And then...
Sorry, can I just ask one question? Go ahead and finish your thought there.
No, and I was going to say that once that is a question of fact that the jury should decide it, instead of doing a mechanical application of the TM 2008 case saying that fiduciary duties don't apply to LLCs. Well, I believe that TM 2008 doesn't say that. That it says you look at the operating agreement, and if those provisions, those obligations are fiduciary in nature, then there could be fiduciary obligations which should be decided by a jury, not before the jury has a chance to hear them.
My question was just, what's your response to the assertion that Dr. Kilpatrick doesn't have standing to assert a derivative claim on behalf of SESC?
That he doesn't have a standing to assert a derivative claim.
It goes to his claim of consequential damages.
Well, he would have, the claim of consequential damages is that if the click fees would have been recovered, he would have shared in the profits in the Scottsdale Surgery Center.
But isn't that a claim they would have had to, shouldn't they have been a party or been part of the litigation to assert a claim that they were denied, that they weren't adequately compensated?
Well, it would have been, when you look at a consequential damages, is you look at somebody's actions, how am I damaged, what's the consequence of my damages? And so the consequential is that I was damaged by not as my membership here, but the benefits that flowed from my membership of the other entity, I would have enjoyed those monies as well.
But as I understand it, it's not that Dr. Kilpatrick was personally damaged, but that his interest in the LLC was damaged, right?
For his trust interest in the LLC.
Yeah.
And that's kind of the distinction that I think is being kind of overshown, that even though there's a trust and then there's managers, you still have the trust, which is really the member of the LLC. And the trust, and you have the appointment of the administrative manager who then is managing all the interest for the benefit of these trusts. So I thank you for your time.
Thank you for your arguments. We'll take this matter under advisement and issue a decision in due course. With that, we're adjourned.